into the latest developments in the world of European patent litigation. I'm your host, Tilman Pfrang. Today, we are tackling one of the most commercially valuable technical fields involving IP, standard essential patents. Joining me are Giles and Julian Würmser. Sam is a UK and European patent attorney with a great deal of experience of litigating in the UK. Julian is similarly a European patent attorney and has been extremely active in contentious matters before the UPC. Hello, Sam. Hello, Julian. Nice to have you here.
Hello, Tilman. Nice to be here. Thank you for the invitation.
Yes, thank you also. Great to be here again.
So, for both of you, setting the stage, Julian, let's start with you. Could you briefly explain what is standard essential patent and what the meaning of the term FRAND is?
So maybe we start at the very beginning. SEP, Standard Essential Patents. So the general idea here is that you have patents that are covering a standard, and a typical use case for that, as audience knows, would be, for example, Wi-Fi. If you want to communicate with a laptop and the internet, then you might need Wi-Fi, and actually this Wi-Fi standard is covered by certain patents, and these are called standard essential. And now, since everybody wants to stick to the standard, there needs to be an option to make this technology available to everybody. And that's basically where the term FRAND comes in. That stands for fair, reasonable, and non-discriminatory. So basically, it should be a license where every market player has a fair access.
Great. Sam, could you tell me about how the UK courts took a defining role in such FRAND cases?
Of course. So the UK Supreme Court decided in an unwired planet that the UK does have jurisdiction to set global FRAND rates. Now, the reasoning behind this is effectively if you consider if it had taken the opposite view. So if a standard essential patent holder had sued in the UK and the defendant had simply been set a UK FRAND rate at the end of that case, then the patentee would only have received FRAND royalty for the UK. And obviously the implementer would normally be, as the case that Julian has out with Wi-Fi, would be implementing across the world. Therefore, effectively, the patentee would then have to go and seek that FRAND royalty from every jurisdiction, or at least major patent jurisdiction across the world, and that would take excessive cost and time and wouldn't be fair to the patentee. It wouldn't be in line with the FRAND terms. Therefore, the UK courts have decided that it's fair that a jurisdiction sets a global FRAND rate, and therefore that where it's sought in the UK, that the UK can do so, unless there is another jurisdiction that would be better suited to that particular case.
Julian, Sam mentioned already FRAND rates and so on. And what is, in a global sense, a global license offer, and what is the effect of refusing such an offer?
Generally, there has been a wide-reaching discussion whether there could be any FRAND license that is not globally available. So a global license offer means that it basically covers the whole world. And for the FRAND term, just to kind of recapture this quickly, we had this before. The ECJ, they kind of set up a certain scheme. It's known as the FRAND dance, and it basically makes both parties. So we have the so-called implementer of the standard essential technology, and on the other side we have the SEP owner, and they have to interact in a certain way. And the ECJ, they set up a very strict rule how they should be interact, and that's called the FRAND dance. To cover a couple of these steps, so first you have to have, of course, the notification of infringement, then a declaration of willingness to take the license, and so forth and so forth. So both have to behave very cooperative towards each other, and if one of the party stalls this sort of scheme or this dance, he will not have most of the time, in the end, the potential implementer or the implementer is the problem. If the implementer doesn't behave properly, he will not have, if he's sued at a later stage, he will not have access to a FRAND rate anymore. And so that's the idea. If an SEP owner offers a license and you don't behave towards that in a certain way, that's considered a refusal, and that refusal will lead you in a situation where you can get sued, and if you're out of luck, you will be locked out of the technology permanently.
Sam, coming back to the UK practice, how has UK practice evolved, and what services does the UK provide in relation to SEP disputes?
So because the UK was the first jurisdiction to set a global license term, there have been many trials in the UK that have reached completion as compared to other jurisdictions. And the UK has kind of been finding its way as to the best way in order to achieve justice in these kind of scenarios. So for standard patent trials, we have in the UK a first trial that is about infringement and validity. And then we have a second trial that is about the quantum of damage. And then sometimes there's a third trial about costs. And that sequence is pretty much set. Now, for FRAND trials, there is also an additional step at which the FRAND license and rate is set. And that's effectively instead of having a kind of quantum of damage. So for standard essential patents, there have been a few cases in the UK now where that sequence has been changed, where first of all, we have the FRAND trial, and then later there would be the assessment of infringement and validity. That's quite important because it means that these trials happen much faster and you reach that FRAND assessment first. And when you think about standard essential patent portfolios, they're generally very large. They have many patents in them. And generally, when an implementer is taking as a FRAND license and they take a lot of patent licenses as part of that bundle, some of those patents are going to be quite untested. Some may be invalid, some may be valid, some may not cover the standard, some may cover the standard. And there's a reasonable amount of uncertainty when they're purchasing the standard as to which ones are actually the valuable patents and which ones are not. And so by taking the FRAND trial first, you can effectively agree that for a reasonably substantial bundle of patents to accept a rate, and in some cases actually then not even go to the subsequent trials, because that rate is based, at least in part, on that risk that some of these patents are invalid and some are not. So it's maybe slightly lower than if all of the patents have been tested. For the patentee, this means that you reach that assessment quicker, so it's more proactive. And for the implementer, it can mean that you don't have extremely expensive and long-winded trials involving infringement and validity of many, many patents. So it can make the whole process more akin to the commercial reality. In addition, we've also seen in the UK recently a number of applications for interim licenses. So whilst a patent trial is ongoing, there is no license for the implementer, and should they ultimately, it's possible that if they don't accept the FRAND license, then they would have an injunction against them. So there was a case recently, Panasonic v Xiaomi, where it was going through the UK courts, and Panasonic were the rights holder, and they decided that in addition to the UK action, they would also take actions in Germany and at the UPC. And due to this, Xiaomi applied for an interim license, and this was effectively to cut off at the knees the proceedings in other jurisdictions. And the UK court agreed that Panasonic, as a FRAND, being fair, reasonable, and non-discriminatory, should not be seeking injunctive relief in other jurisdictions whilst it has accepted that the UK is going to set FRAND terms. And therefore, they granted an interim license, which effectively stopped the actions that are ongoing in Germany and the UPC. And it showed that as an implementer, you can request an interim license, you can be successful and gain one, and that can really change the course of that litigation. In that particular case, it actually led to a very swift settlement between the parties. I think it shows that you have to be very fair-minded when you are the patentee and you are seeking to enforce these rights because they are standard essential. You always need to bear in mind that in seeking an injunction, you may not be seen as being fair and reasonable. Additionally, the UK has launched the Standard Essential Patent Resource Hub. So that's mostly targeted at UK companies, but I'm sure the resources can be accessed by other entities as well. And it's there to provide information on standard essential patents. And it's just it's a useful way to provide more information, especially to smaller entities that aren't so used to this world.
Julian, Sam has already mentioned the UPC side of the coin, and we covered this UPC SEP practice in several previous episodes, as far as I remember. So maybe only in short, how has the UPC practice meanwhile evolved?
Well, to answer this question, I still have to quickly go back to the German practice, and basically when you look at the German practice, there used to be kind of two views on this. The one view was kind of the view that what the ECJ put out, as I already mentioned, as the FRAND guidance has to be followed like step by step, so very strict. Every step has to be followed by the other step, and that was kind of the one approach. And the other approach was the approach where these steps they're interesting and you should kind of follow them, but in the end it's more essential that the implementer shows a constant willingness and really drives the negotiation towards having a license. So he has to, from my perspective, the higher burden is put upon the implementer since he's the guy that wants something. And from my perspective, since a lot of rulings, or actually all of the rulings in that field have been taken by the German local divisions, and the later approach is what the UPC is currently following. So there's more pressure on the implementer, and there's very rare chances for an implementer to say the SEP owner did not behave properly, so I couldn't follow the scheme that is laid out, and I couldn't show myself willing enough. So from my perspective, it's very much the second approach that I just described.
Now a question maybe to both of you actually. What are the similarities, in your opinion, between UPC and UK practice, and what are the differences?
I think the UK is extremely likely to accept jurisdiction, and I think the only time that they'd be unlikely to is if proceedings abroad were already far advanced when the UK court came to deal with the matter. And therefore, it's a jurisdiction that a lot of companies have been using just because there is that certainty that it will take the matter on. Julian, I don't know if that's ever so slightly different to the UPC.
Maybe to quickly, the comparison against German practice I already said. I think they pretty much follow each other. So the way how they do it is very similar. The only thing is what Sam already mentioned. Theoretically, there's this option or this new idea that you can sue for a FRAND license. And the view of the German courts is it's not possible to do that at German court, or it's going to be very difficult. With the UPC, they say generally we are a court that is available to do that. So you can come to us, but if you want to come to us, there needs to be a tangible reason. So you cannot just out of the blue sue for a FRAND license for particular technology from a particular SEP owners. So there needs to be a hook that attaches the whole case to the UPC. So they say generally we are available for that, but we need some connection. And if my understanding of the UK practice is that this connection can be very, very thin on the UK side.
I think that's accurate, yes.
Okay, perfect.
And just in terms of strategy, I think with the UK, with recent case law, it's all about being proactive. So whether that's deciding which jurisdiction you want to be in, so being proactive in that way, or in terms of trying to file applications for interim licenses, and even using those invalidity actions that you just alluded to as a source of FRAND litigation to set the jurisdiction. I think the UK has certainly been trying to allow the strategy to be very proactive, and I think that is somewhat different to the UPC, which is more reactive to the hook, as you say.
Is there anything else our listeners need to know about strategic options?
I think that's the main take home really, is if you want to make sure that you're in a specific jurisdiction, then do that proactively. So whether that be the UPC, UK, further afield, China, USA, whichever one you want, if you think you're going to go into some kind of dispute, be proactive, decide which jurisdiction you're going to go into, and then try and make sure you go there, because there can be advantages depending on whether you're the implementer or whether you're the patentee. For example, I think Germany's regarded as having a very patentee-friendly approach, and those considerations have to, be borne in mind.
Okay, well, thank you both for this very helpful insights. That brings us to the end of today's episode on standard essential patents and FRAND at the UPC and in the UK. It's clear that as standard essential patents are some of the most valuable IP rights, they also come with technical complexity. To our listeners, thanks for tuning in. If you found this episode helpful, make sure to subscribe, share, and leave us a rating. And of course, stay tuned for our next episode where, hopefully, George will be again your host. Until then, I'm Tilman Pfrang, and this was UPC Insights. Take care and auf Wiedersehen.